Hey guys, if you've been following our blog or watching any of our video content for any period of time, and especially if you're a Mesa Properties client already, then you know that we've been talking a lot about the Tenant Protection Act, or the TPA, or in its previous iteration, what it was known as was AB 1482. And I'm bringing this up today not to beat a dead horse, but there was a new Senate bill that passed, Senate Bill 567, that goes into effect on April 1st, and it has several changes to the original version of this bill, which was AB 1482. We've begun just referring to it as the TPA because that's what the government is starting to refer to it. And in April, when this thing goes into effect, it's being removed from the civil code and made into its own thing. So SB 567 is what that is. And in this video, I want to show you something that is straight from the Attorney General's Instagram page and his press release that is directed at tenants, landlords, and property managers, but is specifically and clearly geared specifically towards tenants. So this video is intended for rental property owners or landlords. And as a property management company, that's who we service. And so that's the angle that I'm coming at this with and what I want to show you. So let's take a look at this screenshot that I've got here of this press release from Rob Bonta. Now, if you'll recall, Rob Bonta was an assembly member before he was California's Attorney General, and he co-authored AB 1482, which has morphed and changed over time into the TPA as we have it today. So this is his baby. He was instrumental in bringing this to pass, and he's very passionate about the enforcement of this specific law. He's made that very clear. In his most recent California DOJ weekly email, the main topic of that entire newsletter was the TPA and his enforcement of the TPA. So I want to show you this because there's some things I just want to point out that if you don't understand this law, this is very misleading. And again, this was probably mostly directed at tenants. And so the reason I want you to be aware of this as a landlord is because you're going to have tenants that might say, oh, no, the California AG says X, but it's not really the full story because the law says otherwise. And he kind of frankly just skirts past that, breezes over it, and says true things, but without giving the stipulations of what make them true. There's many landlords. In fact, over 80% of the landlords that we service are exempt from this law. But if you read this press release or watched his video, which I'm going to show you, you wouldn't know that. And your tenants wouldn't know that. And so it's going to create a lot of confusion. And so if you don't know the law, then you're going to have a hard time rebutting a tenant or an applicant who is claiming that they are protected under this law, when in fact the property very well might be exempt. Now, before I dive into the details of this specific press release and the video from Rob Bonta's Instagram page, just a quick legal disclaimer. I'm not a real estate attorney. Mesa Properties is not a real estate attorney. Nothing that I am about to share with you or say should be taken as legal advice. If you have questions about your specific situation, call a qualified real estate attorney who will be able to advise you. So this is for informational purposes only, and again, is not meant to be taken as legal advice. So here's a look at that page. If you scroll down just a little bit, he says that he wants you to know your rights as tenants. And here's what he says. Generally, your rent can be increased by no more than 10% per year. That's true if you're subject to the TPA or if there's a state of emergency in effect. You can only be evicted by court order and generally only for just cause. The eviction piece is true. The just cause piece is only if you're subject to the TPA, which again, most of our owners are not, because if it's a single family home owned by an individual and the correct 12-point font language is in the lease, then that property is exempt and there is not a just cause need to be given when terminating a tenancy necessarily. Your landlord must repair health and safety issues. That's fine and true. It also says your landlord must return your security deposit and must itemize deductions. Makes it a little bit hard to see, but within 21 days of you moving out. And when you first read that, you would, on its face, it seems like I have to give the full security deposit back within 21 days, which is what the law says. But it also says if I'm not able to do that, then I can make a good faith estimate and I can provide that to the tenant. And then I have the amount of time that I need beyond that to complete the repairs and then finalize the disposition within 2 weeks of receiving final invoices from any vendors. But if I'm a tenant and I read this and it's been 21 days, I got my good faith estimate from my past landlord, I would say, hey, you haven't completed it. I don't have the full amount back. You're in violation of this. And they might even take you to a ca.gov website. And the way that this reads, if you don't know the law, you might say, wow, did I miss something here? But you didn't, but there's no mention of that good faith estimate. The rest of it is fine. They can't discriminate against you, of course, for exercising rights. That's totally true. And then it goes down and says that the landlord or property manager under the Tenant Protection Act. So rent may not be increased by more than 5% plus the changing cost of living, which is CPI, or 10%, whichever is lower, over the course of any 12-month period. That's true if the property is subject to the TPA. But if it's a single family, a condo, a townhome that's owned by an individual, and again, that proper notice is in the lease, then that's not true. You can't increase it by more than 5% plus CPI. And then also this relocation assistance equal to 1 month's rent. Again, that is true if it is subject to the TPA. But again, many properties are not subject to the TPA, especially single families that have all those other stipulations that I mentioned. And yet it says, if you were to read this, that you would have to give your tenant 1 month's rent. So I just point this out and I want to show you the video that he did so that you can be aware of the messaging that your tenants very well may be seeing from the government themselves. So let's watch this video really quick from Bonta himself.
California is facing an existential housing and homelessness crisis. It's why California DOJ's Housing Justice Team is focused on expanding affordability, accessibility, and equity in housing across the state. That includes making sure you know your rights as a tenant. So let's dive in. First, you can only be evicted by court order. If you get an eviction notice, get legal help right away. And generally, after you've lived in your unit for 1 year, you can only be evicted for just cause. For most tenants, your rent can be increased by no more than 10% in 1 year. And depending on where you live, this cap may be even lower. Your landlord must repair health and safety issues like providing working plumbing and heating. Your landlord must return your security deposit, and deductions for things like unpaid rent, cleaning, or repairing damages must be itemized within 21 days of you moving out. Your landlord must provide reasonable accommodations if you're a person with a disability. And finally, your landlord can't discriminate against you based on your race, religion, gender, sexual orientation, disability status, marital status, income source, veteran status, and certain other characteristics. For more information and resources on your housing rights, visit oag.ca.gov/housing.
So why do I show you that? Again, nothing that he's saying is untrue, but it's not given the full context of when someone is actually subject to that law. And so I tell you this because as a landlord, you have to know the laws. You have to know when you're exempt, when you're not, what the right thing to do is. It is getting more and more complicated all the time, and it's being exasperated by the very attorney general of our state putting out this information and not qualifying it, not telling you when you're subject to it and when you're not. It's going to create confusion. It's going to create situations where tenants think that they're being mistreated unfairly or that their landlord is not abiding by the law. And it's going to create landlords that frankly see something like this and go, wow, I really screwed up and I didn't know that that was the case. Now, if you dive deeper into these individual press releases, to be fair and to give him credit, he does talk about the different exemptions and who's exempt and things like that. But you really got to get into it. And obviously in that video, there was no mention of that. So I point that out just to say the value of a property management company or the value of knowing the laws yourself is higher than it's ever been because the stakes are higher than they've ever been. There are now ways for the tenant to come after the landlord for treble damages and attorney's fees and things like that for violating this law. So the penalties are just higher and higher. So I implore you, as a landlord, you need to know the laws. You have to keep up with this stuff because the California government is not doing you any favors with videos and press releases like this. So you have to know it yourself, or you need to trust a property management company that is up to speed on this type of stuff. So I hope you found this helpful. Stay tuned, and we will continue to update you with things like this as they come out.